Good morning, everyone. Good morning, guys. I would like to remind you all to open your camera, but later because we still wait for the Sir Muhammad Faisal Sholeh. So it will start when the lecture join the Zoom. Thank you.
Bago na na ano boy? Bangko bala boy ata po boy. Puti.
Andrea tuning, please mute your speaker. Thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. I'm Vina Damayanti, the facilitator today. Before the course start, let's pray according to our respective religions. Pray within. Finish. Today's course is about Indonesian justice system by Mr. Muhammad Faisol Sholeh, SHMH, as the speaker. To Mr. Muhammad Faisal Sholeh, SHMH, please start the course today. Time is yours. Thank you.
Okay. Okay, well, first of all, Assalamualaikum warahmatullahi wabarakatuh. Thank you very much at the very first time. First of all, to the Ahmad Dahlan University who has invited me here. Thank you. This is such honorable for me to meet you all, the educated people, of course, from various country, from various, I don't know, all of you are students or all of you are academicians, or also perhaps some of you are practitioners like me. Let me introduce myself. I am Muhammad Faisol Sholeh. I am an academician, researcher, and also legal practitioners. I'm a lawyer. So in case of Indonesia's judicial system, I also take a part in theoretical and practical. So it's going to be really interesting to be discussed today. First of all, perhaps to these sections, there are two terms that we are going to underline in regard to the judicial system and also justice system, how we use those two terms in Indonesia and how we actually understand those. That's actually the main idea what I'm going to deliver today. So let's step to the first part, to the first slide. Next. Okay. Discussing the judicial system, we cannot be far away from how the legal system is applied in the country. Harold Gilbermain has delivered that there are three criteria to understand the legal system itself. First is the whole set of the specific rules and procedures, which can be therefore distinguished from other social rules, which means that the system itself were built from the bottom on the social condition. And the second one is in general and then relatively consistently applied by a professional authority structure. Then the social foundation, the social conditions that were become a basis of the system itself were taken into the authority to be set in general to be applied in order to control the social process that occur in society. So from society to society, that actually the meaning of the legal system, which if we relate it to the condition of Indonesia's legal system, we can find that Indonesia is a legal state based on the Article of 1, Paragraph 3 on the 1945 Constitutional of the Republic of Indonesia. So the idea of Indonesia's legal state is how we implement the law over the power, or we say it is a mastat, a concept of mastat. Rather the mastat idea, we use the restat idea. If perhaps it is familiar for some of you to understand the comparative legal system, you'll find that over the power that is controlled the country, we use the legal state. We use the legal system. We use the legal power to implement everything on the country. That what actually the main idea of Indonesia as a legal state. The second one is the legal system is unified element, inter-alliance, regulations, stipulations, which are influenced by cultural, social, economy, historical, and so on. So basically, if we understand the legal system that before that delivered by the herald, we understand the main idea of the legal system is coming from the bottom, from the condition of the society that is pursued and oriented to control the social itself back. Now, the Indonesia does it too. Indonesian legal system were also built by the condition of by the original condition of Indonesian social life or the society in Indonesia. Why? We have actually 4 times revised or having an amendment to our constitutional uh, yeah, to our constitutional in Indonesia. And one of the basic point or fundamental point that we also revise here is the idea of Indonesia as a legal state. Before that, before today's article that we have mentioned just now was about the legal system idea. Indonesia was also or used to have an idea of Indonesia is a legal state, but it is interpreted by the power authority. That is the House of Representative as a representative of the society. So the era before this principle was applied, understanding. Create an idea that people were represented by the House of Representatives. So actually, the law must also be controlled by the society through the House of Representatives. That what actually become a dilemma at the time. Then the government of Indonesia decided to change it and become the idea of legal state today that we have recognized. And the third point is law in Indonesia is a mixture of the European legal system, religious law, customary law, and customary law. Most of the systems adopted both civil, criminal, are both Netherlands because of the historical aspect of Indonesia. Past was colonized by Dutch East India. So basically, if we understand the history of Indonesia, we also have noted that Indonesia was colonized by the Dutch for a long time. And one of the influence that was given by the Dutch is about the law or the legal system itself. That is why we use today, as a consequences of that colonization, the concept of civil law or European legal system. That is the same with what actually applied in the Netherlands or the Dutch. So how about the religious law and customary law? Yes, Indonesia also do accommodating those together as a mix. Even the formal or the juridical form of that is in the form of European legal system, but we don't actually forget our own identity as majority of us, or majority of Indonesia as a Muslim, and also upholding a religious aspect is very important in our life. So before the Dutch come in, the religious law were implemented at the very first time, as long as also the customary law. We have really long journey of implementing the customary law. So either it is written or unwritten, the legal system or the justice system included part of the legal system have to be really understand those, because not only written system but also in written system can be a basis of implementing the law also. in the context of the justice system. That's what actually we would like to discuss in the next slides. Okay, next. Okay, next slide. So this is a little bit an overview, basically how the judicial system were built in Indonesia. Because of Indonesia was colonized by the Dutch, so the Indonesian judicial system is influenced by the Dutch legal system. So before Indonesia declared its independence, we had in the era of the Dutch colonizations, we had four institution of the courts. First, we call it as the government court or government rechtbank, which it's all covering all the Dutch Hindi. So this court is specialized for the Dutch Hindi people or community. And the second one is the local court. We call it in Indonesia as a pribumi court. It is a local court that only found in a direct administrative era of the opposite era. So this court, if the first court is covering the Dutch in these cases, the local court is only for those who are local, like Indonesia, what we call it is a pribumi in that era. So that we use the term the pribumi court or Indonesian rechtbank. And the third court, we had the Swapraja court are located in direct autonomous area except for the Palu, Alaman, and Pontianak Swapraja area. So this court is also a local court, but the meaning of local here is the little bit different from the local court. The Swapraja court are local because its existence is only in a view area in Indonesia, so that it is called as Swapraja court. The Swapraja area. In Indonesia, we have except for Papua, Laman, and Pontianak. And the last court, we had the village court. This could be, if today we compare, there's no comparison actually, but the village court here is really specific applied in Indonesia in really small area like a village, so that there were so many village court at the time of that era that is applied for the size of village court itself. So how were the power they were implemented at the time? Basically, they were educating the same thing, like what actually are implementing today, the criminal cases, the private cases, small cases that were implemented, that are implemented as small cases implemented were becoming really huge at the time because of those four courts, which were almost not capable to judge really specific cases. So those types of codes were exist at the time, and not specifically have a purpose to what actually we recognize today in our judicial system, like specialized for the criminal cases, private cases. But those types are different from what we call it people who can be judged, or a subject of the law that can be judged under that court, like local in some areas, and also for the Dutch people, for the government court. And next slide. Okay, next slide. Okay. However, those four types of courts were not for the for really long time. It was changed by the existence of Article 3 of Law Number 1 of 1942. This law was existed before the Indonesia's independence. So basically, this law was declared by the Dutch government at the time, or the Dutch Indian government. It was giving three main regulations, perhaps, in regard to the previous condition of judicial system, or the courts that we had. First changes is in regard to the abolition of the distinction between the government court and the local court. So if the previous slide we discussed that there were to differentiate between the government court and the local court, by the existence of this article, this regulation, it was changed. It was merged them and make them together, and then there was no any differentiations anymore to those codes. And the second regulations are the second point of that regulations was also mentioned is about judges for the European cases so abolished. So there was no really specific judges for those types of courts. If you understand that at the era of the government case court, or the era of we call it as simple things, people or that people at the time were judged by the court or by the judges that also coming from the judge. Likewise, in the judge for the local group, they also coming from they were also coming from the local community or local like Indonesia. So Indonesia for Indonesia, Dutch from the Dutch. That what actually has been changing in this through this Article 3 of the Law Number 1 of 1942. Okay, next slide. So that this actually become a main idea of these discussions today. So why, if you understand that Indonesians today, most, not all, I guess, most of the idea of Indonesia judicial system use the term Indonesian justice system rather than Indonesia judicial system. Why? Because some of them argue that justice system is actually not only covering the judicial system that we are implemented today. Justice system is more than that. We are not only seeking for the law, we are not going to apply for the law, but we are going to apply for the justice. That's why we use the term, most of us, included me, actually use the term of Indonesian justice system in all aspects, either in criminal law, private law, or in general term that we are applied today. So Indonesia's justice system is commonly used by most of Indonesia rather than the judicial system to coverage all the terms, all the means that we are going to express to this kind of term. Why we use that specifically? Technically, we are going to show you how it become a reason perhaps to use the justice system rather than the judicial system itself. Okay, next. Okay, this is the history of judicial power in Indonesia after the Independence Day. So after Indonesia's proclamation that the independence from the colonizations, we face the era of old order era at the time. So in that very first, no, not very first, in that very first era of Indonesia's after independence, we directly created what we call as the Ministry of Justice. That Ministry of Justice were having an authority to manage or to like organize, implement the power of judicial at the time. So the formulations of the 1945 Constitution of the Republic of Indonesia concerning the principle of independence of judicial power does not include the organization of organizational relations of executive power, so that the so-called principle of independent judicial power can be interpreted to apply only to its judicial function. So if you all guys, noted that we used that era as executive power is more dominant at the time, so that included part of the judicial system, or the judicial power were managed by that Ministry of Justice, which means from the executive power at the time. Not we didn't have a specific power of judicial at the time like what we have today. That's why at the time the executive was so dominant to implement, also include the judicial power. Okay, next slide. Next. Can we? Okay. The state of the new order era. That was the beginning how we understand that the judicial power is really important. If we noticed notified that the previous era, the old order era, we had an idea. We just had an idea of how we implement the justice power. But in this era, we already had a justice era. We were also more specifically created the Ministry of Justice to declare its authority to manage the duty of the duty of judicial power at the time. So in this moment, in that era, the judicial power is not fully independent. Even the idea was written under the Constitution, but yet in implementing that constitution, it still cannot be denied that the president, the executive one, were still dominant at the time, and the results, we don't have any really original and independent, really independent judicial power. Article 11, paragraph 1 of the body that carry out of the judiciary refer to Article 10, paragraph 1, organizationally, administratively, and financially are under the authority of representative, the parliament consent. So the parliament here referred to the Ministry of the Justice, which we had understand that that ministry or that department was the authority to implement the judicial power at the time. Okay, now move on to the next slide. Next. Okay, post-reformation situations. This era or that era, officially we announced that a basic provision of judicial power were implemented organizationally, administratively, and financially are under the authority of the Supreme Court. So that concern, in that era, we already declared that we have an independent institutions that specifically have the authority to organize or implement the judicial power. So it was changing. If we noted that in the previous era, the authority of judicial power was still upheld by the executive one, and this era it was changed. Now we had the Supreme Court that is implementing the judicial power up to now, what we recognize as the Supreme Court. Article 1, number 1, we had a two times revised, not 2 times actually, but the main idea of this was writing under the two regulations that we had. First is Indonesian's law number 4 of 2004 and law number 48 of 2009. The judicial power is the power of an independent state to administer justice, to uphold law and justice based on the Pancasila. This is a reason why we rather use the term of the justice system that previously I already told you guys, because the court, the justice, or the judicial power that we are implementing today not only uphold the law, we are also uphold the justice, or we can say that justice over the law. Law cannot be said law cannot be said as a law if this is not a justice. That what we recognize in Indonesia, and it must be based on Pancasila. Pancasila is ideology that is implemented by Indonesia. From that ideology, we have Britain, we had translated into constitutions of 1945. That how we recognize the judicial power in Indonesia as a justice system in Indonesia. Okay, next. This is what we had written on the Constitution, 1945, chapter on the judicial power, Article 24, which stated that the judicial power is an independent power to administer justice in order to uphold law and justice. So basically, we are seeking for the justice as a main post. And the second one, judicial power is exercised by the Supreme Court and the judicial bodies under it, like a district court, religious court, military court, state administrative court, and by a constitutional court. So we, from this statement or from these regulations, we already had now an idea to understand this actually a little bit. How does the judicial court or the judicial system is implemented in Indonesia? Okay, now let's go to the next slide by detail. Now, basically, this is what a main idea that was previously explained by the regulations. So current Indonesia judicial institutions, we had Constitutional Court, we have Supreme Court, and we have the Judicial Commission. We have 3 institutions that manage and implement the judicial power today in Indonesia. And under the Supreme Court, we have still courts body. We understand is a types of high district court, religious court, military court, and the state administrative courts. And those courts were also they also have an appeal on it, like high court, religious high court, military high, and state administrative high. How we understand that in detail? Okay, let's explain it. Can we next slide? Supreme Court, so under Article 24A of the Indonesian Constitution. So Supreme Court, or SC, has the duty of authority to examine and decide we had actually four authority that is implemented by the Supreme Court under this article. First is application for cassation. So cassation means here this Supreme Court is having the authority, what we call is judex juri. That's why it is after the appeal court, they or somebody can still do an evort to do a cassation by submitting it to the Supreme Court. And the second one is disputes about the authority to educate. Okay, continue. And the third one is a request for the review of court decisions. We call it in Indonesia as peninjauan kembali. So this is basically as the authority for judge or for the court to actually look back what actually if there is no form or a new fact of law or the new the new fact that were not shown in the previous cases on the district or even in the high court were not shown, and after that it is found it was found after the court decisions, we still can do the review of court decision itself to the Supreme Court, and this is unlimited. And the next one is examine the regulations under the law against the law. The law means here, I don't know what you understand it in your country, but we had a hierarchy of regulations in Indonesia, and the number one or the highest one is the Constitution 1945. So the 1945 is really is really a basic foundations how we formulate the regulations under that constitution. Like we had the second one is undang-undang. Undang-undang here, the law is the law that is regulate in general for a specific public. So it is rattling. It can be really heavy to understand, but I try to explain it to you. But under that undang-undang, we had peraturan presiden, president regulations, and that we also had district or district regulations, not district regulations. Yeah, specifically is almost the same like that. We also had the regulations of House of Representative until the village one. So from the highest to the lowest level, that hierarchy of Indonesia. Next meeting or somehow you also or perhaps you have the specific classes on this in this short course also that is discussing about that. It is also interesting, and you also can know more how the hierarchy of Indonesians regulations, but it is one of the functions or authority that is upheld by the Indonesian Supreme Court, examine the regulations under undang-undang through undang-undang. Okay. And other authorities, okay, move. No, move. Next. Good. So other authorities, we had the specific one here. So basically, if we notice these authorities, the Supreme Court can, the Supreme Court can regulate, can do the power over internal institutions. They had yeah, for bodies of for institution of the court, for institution of the courts that were built up under that Supreme Court authorities, like a district court, uh, religious court, military court, and then state administrative court. The Supreme Court here is having the main controlled, can be a controller for those institutions. They also manage the administrative by themselves and also by those bodies of justice court. They also can do a technique or giving an information on matters relating to judicial techniques in regard to the aspects of implementing the state's law, and giving instructions, warnings. Yeah, warning means here is how actually the justice system implemented by the institutions below. So if there is wrong or anything like going not going, yeah, it is part of the control functions, actually giving controlling functions given by the Supreme Court to its institutions, giving legal considerations to president, provide informations, considerations, and legal advice to state government institutions. That all of the other authorities that were regulated under the laws in Indonesia, having by the Supreme Court. Okay, next. District Court here, yeah, it is one of the body that was regulated under the the Supreme Court. So if we analyze, we saw the concept of Indonesian's institutional justice system, we find a district court itself. We had two regulations here, 24, and now we had 20, 2000, 2004 and 2009. We implement now is in the 2009 the amendment of general courts in regard to the general courts. Okay, we use the term general court at the previous discussion. Why we use that general? We use the term of general court because we also have the specific court. The general court mean here is the district court, which means that we had criminal cases and private cases to be adjudicated or to be judged at that court. Rather than to that, the specific court here that we are also going to know after this is more like a specific cases or specific cases and conditions that are implemented in a specific term and also conditions too. That's why we call them as a specific courts. Okay, next. Judicial power in general court. Yeah, like what I said before. General court means here district court and high court. In some of it, we use the district court for the first instance, for the first court that are for the criminal cases and private cases. This district authority is to examine, decide, and settle civil and criminal cases at the first level, unless the law provides otherwise. So basically, the main thing that become an authority of the DC district court in the judicial power. So civil and criminal cases in general. What we can find those civil and criminal cases, we had court of criminal court. We also had the private court. Those two codifications become a main basis how the criminal and civil cases in practical were decided by the court. So the judges we're using those basis regulations to actually implement uh, uh, or to decide and examine the the criminal cases or even the civil cases in the court. How about the High Court? The High Court is an appeal court. So when you done really how we call it in English, really, I mean, okay, I'm not good with this decision, so I can go to the High Court to resubmit it, not resubmit actually, to yeah, to ask them that the previous decision of the court uh, was not correct. That actually the power of HC as an appeal court, that to examine, decide, resolve cases decided by PN. Here is DC. Sorry, we call PN in Indonesia as Pengadilan Negeri, but in English we use district court. In Indonesia is PN, and I forgot to change that. Is the first and last level court regarding the last competitive between DCs in that jurisdiction. So if we talked previously about the Supreme Court, we underlined that Supreme Court is having an authority to judicially having an authority to have a judex jury, which is oriented to show how the right and wrong of using the regulations. But in district and high court, we rather than prioritize how the right and wrong of any facts in the cases. So if we declare that those differentiations, actually we understand that the judicial power in general court is really different to the Supreme Court in case of how the way they decide the cases. Even this is the same cases, but the Supreme Court rather have to prioritize how the regulations were implemented or were used in the previous court decisions, and like in the High Court or even in distinct court. Was that right or wrong? The Supreme Court have to give its opinion on that perceptions of orientations, not to judge or decide a case by its fact anymore, like what had been implemented by the district court and high court. That what actually makes them different. Okay, let's next. Now, at the previous discussions, we called it a specific court. Why there was a general court? Because we have special courts. We have the specific courts like juvenile court, corruption court, commercial court, fisheries courts, human rights courts. Unfortunately, we cannot explain those in specifically because of the limitation of time, but there must be really a lot of things interesting. I mean, in discussing those specific courts. Other than these courts, actually we have another, or I mean, like we have another courts in specific, like tax courts and so on. So we have a lot of special courts also, rather than the so we have this also specific courts here. Juvenile courts, corruptions court. If you understand the case of corruptions in Indonesia, is It's great actually. Moreover, you guys, if you're interested to have a comparative studies, perhaps we got the spatial quads between your country and Indonesia, it is going to be interesting. Um, oh yeah, it is going to be interesting because Indonesia is specialized. The corruption squad for a long time, but yet I don't know it is effective or not. But this institution it really exists, and these special courts are under the authority of general courts in informal institutions. I mean, so even it is called uh, like a special courts, but somehow this is still implemented under by the like a judicial power in general courts. That's why somehow we still have a dilemma on how to implement the special courts in practical. Yeah, that actually, yeah, I'm sorry, I'm expressing what actually happened today. That corruptions, commercial court, fisheries, human rights courts. We had a special regulations for those special courts. So even the material or form I don't know what to call it in English, formal, yeah, formal material, formal law or procedure, yeah, procedure code, the procedural law and the material law, the substance law. They also they do have a specific one. The subject of the law is specific, the condition is specific, and most of them most of the aspects are specific included. Why we also have to have a specific or special code for those specifications. That actually a little bit how Indonesia is having special codes. Okay, next. Religious code. So I don't know. You guys need to know about these numbers or these laws. I think it is no needed on the other side, but sometimes you also need to understand this because it is how we use it. We understand our law system included today, included to the justice system that we apply today. So religious court specifically only for those who are Muslim. So even we use the term religious means not all religious, not all. Yeah, I mean like the only Muslim, the only Islam that can be, I mean for Muslim of course, that can be educated, that can be judged, the, their cases into this court. So how about another religions? In Indonesia, we had, if I'm not mistaken, we have 6 religions that are recognized: Islam, Christian, and so on, of course, and so on. I don't know, I cannot mention it, but most of them are Muslim. That's why it's has a historical background of religious court were actually declared to the Muslim community, and that up to now is still applied for Muslim. How about another religions community? Their cases can be judged, can be brought to the district court. So the district court, even they can despite they can handle the cases of civil and also criminal cases, they also can adjudicate. I mean, they can also have a case about religion's aspect for those who are not Muslim. For instance, like the example is divorce and so on. So those types of cases can be brought through the district court, not a religious court. Okay, move. Continue. Continue to the next. Okay, okay. Almost the same like a general courts. We also have the first instance of the court. We call it as the religious court, RC. RC has the authority to examine, try, and decide cases between Muslims in accordance with the laws. The meaning of people who are Muslims are people who submit themselves voluntarily to Islamic law regarding matters that are the authority of RC. So for your information, even this is a specific like a specific code for a Muslim, but the Muslim itself can also use another alternative of the court. For instance, they want to use a district court. For some cases, they can use that because it is voluntary. But it is a main idea how actually the Muslim should do or should join to fix the problems, specifically in terms of law. So that the authority of RC here, that is that is accommodated under the law number 7 of 1987, that was revised through 1989, concerning the religious court. Its court are having an authority to first marital aspect, or marriage, inheritance, wills, grants, wakaf, zakat, infak, sodaqah. Sodaqah is like charity, but it is in the term of Islam. We had like, you know, specific thing on the sodaqah itself and Sharia economy. So yeah, Islamic economy and Sharia economy that we call today. That actually what becomes differentiations between religious court and also district court. District court is also having the same things like what marriage, inheritance, will, grants, economies, not Sharia economies, but included to those, almost the same, but not for a Muslim, but for non-Muslim. And for the Muslim, they may take they may seek the justice under their in the religious court. Other than the religious court, if you don't satisfied to the decision of the court, you can still do an appellate court or appeal on the religious high court. Its authority to examine, hear, decide on cases that have been decided by the RC, and is the first and last level court regarding the relative competence between RCs in their jurisdiction. So likewise, we have discussed about the district court and high district court. It is also the same like that as having an authority to have a jurisfaction. So they seek or they have an orientations to find which fact that is correct or wrong in regard to the cases. So if you don't satisfy again to the decisions that were given by either religious high court, you can still do a cassation through a Supreme Court, the same like what we can do in the High District Court or even District Court previously we have discussed. It is almost the same because these institutions are the same under the Supreme Court. Okay, next. Despite the religious court, we also have the Islamic Sharia court in Aceh. So this must be, if I include this court system, is a part of a special court, actually, because this court is only exists in one area in Indonesia called Nangro Aceh Darussalam, or Aceh in simple word we say. So Article 3A of Law Number 50 of 2006 concerning amendments to Law Number 7 of 1989 concerning religious court, that the Islamic Sharia court in Aceh is a special court within the religious court and is a special court within the great court environment as long as its authority constant to the authority of general court. So previously we have discussed the differentiates between the authority of general or district court, district court, and religious court. Yeah, there were two. They are two different. But in the context of Islamic Sharia court in Aceh, their function, their authority can be mixed. I mean, in Islamic Sharia court, the judge can also judge. I mean, they have an authority to decide cases of what religious court has, and also they can also decide civil law. I mean, like criminal cases and also civil cases, like what actually exists in the district court. So the Islamic Sharia court in Aceh is having two functions. Yeah, to authorities for sure, doubtly included what actually the religious court has and also the district court has. Thus together were accordance or accommodated under the presidential decree number 11 of 2003, which changed the term RC to Sharia court. So if we see this, condition of Aceh in Indonesia is having like a spatial autonomy. So autonomy means here, if you have a background from the constitutional court, so constitutional law, perhaps you understand about the autonomy. Autonomy means it's a special condition for those spatial area. That is a policy that were given to those who are spatial in the country. One of the spatial area in Indonesia is Aceh. That is why we give them spatial policy. The government gave a spatial policy in regard to implement this the Sharia or religious, like more to the Sharia law in its area. That's why the authority of the Sharia court, which previously actually, if we know from the presidential decree here, the previous name of the Sharia court was actually religious court. Likewise to the provincial Sharia court. Previously, it was called as religious high court. Like in general, we recognize in terms of religious court. What are the authority or the power that they can that they can decide as courts? First is a family law, ahwal syariah. Second is civil law, muamalah, and the third one is criminal law, jinayah. For sure, not all criminal cases can be taken to this Islamic Sharia court. They also, in Aceh, they also have a district court, which means that the criminal cases can be, the criminal cases in general should still be judged or be brought to that type of court rather than to Islamic Sharia court. Islamic Sharia court in terms of criminal law here is specialized for some of type of crime that were recognized only in Aceh. So the system of Islamic Sharia court is specialized to examine how the criminal cases happens in the area of Aceh and how they execute into translated translated into the decision of court, which represents really the Islamic aspects in Aceh. Yeah, Aceh is recognized as, I don't know what we call it in English. Whereas, yeah, the one of the most important thing is Aceh is recognized as the Islamic area, so most of them are upholding the aspect of Islam, so that Islamic value is really high there, including the existence of Islamic Sharia court. Okay, now let's go to the next slide. Military court. Okay, good. Okay, military court. So the third of the type in the judicial power under the Supreme Court is a military court. Wait. So military court is regulated under the law number 31 of 1997 concerning military courts. Basically, this court is examined through cases of criminal cases for specific Indonesian National Armed Force. MC includes military court, high military court, main military court, battle military court. So it is specialized court or special court also, but not really special because it is part of the court that was established before in any special courts, any other special courts that we have mentioned before. It is still part of that. It is still part of the Supreme Court's body. Yeah, all of them are still under the Supreme Court supervision, including the military court, but it is still not included to the special court. So the main idea of this military court is to examine the cases of only Indonesian National Armed Force, which means that the delicts or the criminal acts that were judged in this court is only a criminal conduct that is in the context of military aspect on military terms. The MC's authority is to examine, educate, and decide cases of military crimes in accordance with law. Okay, next one. I think that's actually the main idea. If you want to know more, you can contact me or anything. Because if you guys know that perhaps this, we name it as a short course, so it must be the short time to explain. And it is difficult for me to explain those together in detail, how actually the aspect should be shown. It is almost difficult. So that if you want to know, perhaps you can join another classes, or maybe you can contact me to more. By the way, as a researcher, I do a lot of research and regard to the comparative study. And if you're interested into this, you can perhaps okay, we can collaborate next someday. I don't know. I'm excited to do that. Okay, next. Okay, next. Hello. That's um what the problem actually happened to, except you guys have another class on this sort in this short course that is in detail explained you, like for instance about hierarchy. I've mentioned before. It is great, I think, because like a system, it can be a components that they cannot be far away each other. If you want to understand one, you have to understand another, because it is the same. It is a system. So as a subsystem, each of them must be combined together. Like for instance, to understand the judicial system, we cannot be far away from hierarchy. If we understand the military court, we have to understand what the court system in regard to the military armed forces and blah 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 blah. That's how actually should be done. Yeah, hopefully you guys understand that. Okay, now let's go to the slide 20. We almost hello. Next. Halo? Halo?
Iya Pak, sebentar, sepertinya ada yang error.
Okay, fine, it's okay. Twenty. Yeah, okay. Now we are talking about the state administrative court, like what commonly exists in the state or in the country. We have a state administrative court, which generally examine and decide a case of administrative in state, and it's almost the same type of what actually appearance in the district and also high 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 district court. They also have an appeal, so that yeah, it is easier perhaps to those who really want to do state administrative court. But I don't know, in practical, district court is more crowd rather than the state administrative court in some of cases. So I don't know what is the problem, but actually, yeah, in some area, like for instance in Yogyakarta, if you visit Yogyakarta is also known as spatial area, yeah, autonomy again like Aceh, but it is specified to what is actually implemented to a government of Yogyakarta. We have keraton like a king. So they, as a king of the area, they can decide. So they can actually create policy in regard to special conditions, but not the state administration. So the people of Yogyakarta were still uphold really cultural aspects of how to respect the keraton, how to respect the king, the government, the governor here, the governor of Daerah Istimewa Yogyakarta, called it as special region of Yogyakarta. Yeah, if you want to write some article or yeah, paper or research, you can also explore about Yogyakarta. Perhaps, I don't know, in your country also have the same things like what we also implement in Indonesia to some areas which are different each other. But it is becoming unique things that for me as Indonesian, I always want to explore more of what actually behind of that. Okay, let's go to the next one. State Administrative Court. The authority is to examine, hear, and decide on state administrative disputes at the first level. State administration dispute is a dispute that arises in the tun is means state administrative tata usaha negara field between a person or civil legal entity and tun agency or official both at the central and regional levels as a result of the issuance of the state administrative court, including employment disputes. What is meant by KTUN? KTUN is a written stipulation, right, by the state administrator. So they're basically as an object to the state administrative court, yes. Official containing administrative object, legal actions based on the applicable laws and regulations that are final, concrete, and individual, which have legal consequences for a person or civil legal entity. Okay, next. Next. State Administrative High Court. If we have the first level of the state, like a district court, we also have the appeal of it. State Administrative High Court. The authority is to examine, hear, decide on cases decided by the administrative court, and is the court of the first and final level regarding the relative competence between PTUN and its jurisdiction. PTUN here, PTUN here is Pengadilan Tata Usaha Negara or State Administrative Court. We recognize that. It's authorized to adjudicate cases of first instance against cases that have used previous administrative methods. So yeah, it is the same like previous courts on the jurisfaction. Even it is jurisfaction, but they must be based on the on object of KTUN. Yeah, like what I've delivered previously. It is a state administrative, so everything must based on the administrative letter written officially by government. So if you don't agree with that, you can submit you can ask the court, administrative court, state administrative court to examine and decide that. That actually the main idea of state administrative court. Okay, let's go to the next one. I have okay. Constitutional Court. The Constitutional Court is written or accommodated by Article 24C of the 1945 Constitution of Indonesia. And specific one is law number 24, 2003 concerning the Constitutional Court. It is the court to exercise independent judicial power to administer justice, to uphold law and justice. So if we previously have discussed about the Supreme Court and its bodies, now we move on to the Constitutional Court, which is one independent institutional court other than the Supreme Court. So it is spread court that have different authorities in terms of judicial power. The Constitutional Court authorized to educate first, examining the law against the 1945 Constitution of the Republic of Indonesia. So if you know that the Supreme Court is having authority to conduct or to receive cases of judicial review from I mean, like under undang-undang or under the law to undang-undang. I mean, like for instance, presidential decree. They want to have a judicial review to MA or Supreme Court. So the basis evaluation of that presidential decree must be based on the undang-undang or based on the law itself. It differs from the Constitutional Court. If the Supreme Court from under the law to undang-undang, under undang-undang to undang-undang, the judicial review in Constitutional Court that is applied is from undang-undang to constitution. So the basic evaluation for the law for the undang-undang itself is constitutions directly. That is to decide disputes over the authority of state institution whose authority is granted by 1945 Constitution, deciding on the dissolution of political parties, deciding on disputes about election result, and the decision of Constitutional Court is final and binding. So at the previous discussion of the Supreme Court and its body, the bodies are under the institutions under the Supreme Court are their decision can still be, for instance, the first appeal, they can do appeal on the High Court. After the High Court, they can still do cassations on the Supreme Court. But in terms of Constitutional Court, your first cases, that is the final and binding decisions. For instance, they have been decided by the Constitutional Court. So it cannot be having an appeal or even a cassation. That is a final and binding. In regard to this is the decision of the Constitutional Court, we have talked about the judicial review. How about deciding on the dissolution of political parties? So basically, political parties here is the main how the democratic in Indonesia should be implemented, as well as how the election results as a process of a democracy should be done. So if there was a settlement between the elections, the result, it also can be given to the Constitutional Court to decide how or which cases of elections result can be brought to the Constitutional Court. Actually, up to now, there is no limitation of elections results. So that in the time of elections, results were announced. Because the constitutional court must be so crowded. There are a lot of cases were submitted to them, and they have to really decide it quickly because from Sabang to Merauke, all the area of Indonesia are large. They together, I mean, like they were together directly at the same time, submitted the cases to the constitutional court. So it must be so much crowded. Yeah, it is. It is crowded. That's why we call constitutional court as a guardian of democracy, guardian of constitution, because their first vision and mission is to keep and maintain the democracy and constitution in Indonesia, to keep and restore the democracy from their power to dissolutions of political parties and election results, and over the authority of state institutions, and for the vision and missions of keeping the huge constitution is by examining or having a judicial review power. To make any regulation is still on the track on the track to the constitutions, to make sure everything under the constitution included the authority of state institutions that are granted by constitution. So the very fundamental passage of this function or authority of constitutional court is to keep those two aspects, constitution and democracy in Indonesia. Okay, move on. So the last one, it is the last slide, I think, yeah, is a judicial commission. If we have Supreme Court, we also have Constitutional Court, we have judicial commissions. This is not a court, everybody. This is an independence commission or independence judicial that have 4 authorities or functions in general. From those functions, I guess you can understand how the existence of judicial power in Indonesia is, and what type of institution is this actually in judicial power. First authority is proposed the appointment of Supreme Court justices and ad hoc judges at the Supreme Court to the House of Representatives, or HR for approval. In Indonesia, the House of Representatives, we call it is the Dewan Perwakilan Rakyat. So yeah, the authority of judicial commission is proposed the appointment of Supreme Court justices and ad hoc judges. Second is maintain and uphold the honor, dignity of the village, as well as the behavior of judges. So basically, it's not village like what you think, guys. Village is village court, like previously for the very first time of these slides were described. This more like, yeah, dignity, honor, huge power, that types of things, as well as the behavior of judges. So the function of judicial commission here is to maintain those characteristics of judges, those supreme, I mean, like those characteristic of judges. Yeah, characteristic of judges. How they use, the judges have to do and make a create justice for society. They have to keep that. And the third one is establish the code of ethics and conduct for judges together with the Supreme Court. So in collaboration with Supreme Court, Judicial Commission can create or establish code of ethics and conduct for judges. And the last one is maintain and enforce the implementation of the code of ethics and conduct for judges. Besides, they create the code of ethics and conduct, they have to maintain it in the implementation to the judges. So from this four authorities that are upholded by the judicial commissions, we can understand that this institution is unique. Even this is not a part of a court bodies, but this role, this institution has a really big role to maintain or to make sure that the justice system is running well as it expected. Why? Because we don't seek only for the law, but we seek for the justice. And to create justice, we need really good judges in it. There is no perfect system. What make it perfect is how they make it perfect. I mean, how the judges make it perfect, how the judges' behavior, how the judges' attitude, how the integrity of the judges is actually. That's why its action of judicial commission itself is to make sure that the judges are in line to the code of ethics as an article to keep them become an honor institution to really create a justice for society or justiciable end in all aspects of in all court institutional, including constitutional court and also for the Supreme Court. Moreover, to the Supreme Court, for each bodies, they can establish the code of ethics, which it actually become a binding rules that have to be really kept by the judges or by the judges in all institutions. Next. The Judicial Commission is a state institution that is independent and in the exercise of its authority free from interference or the influence of other powers. The Judicial Commission is responsible to the public, to the House of Representatives by issuing annual reports and opening access to complete and accurate information. So even we call it as independence institution that is free from interference, any interference or the influence of other powers, the House of Representatives here can still play the role as a representation of society. So the Judicial Commission is responsible to submit their reports, how they work to the House of Representatives. Just only that what actually makes them can still be called as independent, even they submit the reports, but there must be any control. There is still a control between each other, each institutions in judicial power. That what actually cover all the judicial powers existence, a judicial commission existence in Indonesia. For me, it's not going to be simple as this, because if you want to know more about the judicial commissions, how it implements, there are a lot of developments actually, but in general, this is still the same. But in specific one, like for instance, in practical, how they use and maintain how they maintain the ethical attitude of the judges. It's more like a preventive authority that is given to the Judicial Commission. So they also can do promote to society how we respect to the judges. So yeah, if Constitutional Court is guardian of constitution and democracy, if Judicial Commission is a guardian of justice, actually guardian of judge, because they really maintain the ethical aspect of judge, specifically in their decision, that actually cover all the authority of Judicial Commission. Okay, I think that's all. Let's move. Okay, that's, I think, all the aspects of all the discussions in regard to the judicial power or judicial system in Indonesia. I am happy if you have any questions. Perhaps we can discuss, or if there is no time more, perhaps you can contact me on my email. We can discuss there and do some projects perhaps in the near future. Thank you very much for your time. Nice to meet you all. Assalamualaikum warahmatullahi wabarakatuh. I give it back to the Mbak Vina. Thank you.
Thank you to Sir Muhammad Faisol Sholeh. Maybe for the participants have a question or opinion. For Ken Kelvin Tungala.
Hi everyone, good morning. Hi sir, good morning. Hi ma'am, good morning. So I would like to ask a question. Is that the president approved the appointment of the Supreme Court justices in your country?
Can you repeat? Can you repeat it?
Does the president of your country approve the appointment of the Supreme Court justices in your country?
Okay. Shall I directly answer it, or maybe all of the questions are covered first? No?
That's just my first question, sir. I have a follow-up question after that.
Okay. Go on.
Okay, so why it is necessary to put an approval of the president to appoint a Supreme Court justice when the applicants have already screened by the Judicial Commission?
Sorry for the second one.
Why it is necessary to put the approval of the president to appoint a Supreme Court justice when the applicants have already been screened by the Judicial Commission?
Okay. Should I directly answer it, Miss Devina? Okay. Directly. Okay.
Yes, sir. You can directly answer, or if you want to.
Okay. Yeah. Basically, if we thank you. Really nice question, I think. So the president here is, Indonesia is having a separation of power. Basically, that's the point. So executive one is different from the legislative and the judicial, the judicial aspect, the judicial power, of course, included to implement the judicial power in Indonesia. The existence of the president here is just part of control. Like, if we understand that executive to legislative is controlling each other, legislative to the judicial power also controlling each other. The purpose is not is how the abuse of power cannot be done. So that if in the historical of Indonesian institution, the highest one, especially in the era of old order and the new order of Indonesia, the executive heavy was still dominant at the time. But today, that is abolished. That is not exist anymore, because all the powers and in this country are the same. President are the same highest, like is the same highest like the House of Representatives, as well as the judicial power. In regard to the context of the Supreme Court, actually, the existence of president itself doesn't really influence, doesn't, no, actually, the president doesn't have the functions to have, to give, in context of the court, they cannot interfere, or the president cannot interfere the judicial power. The judicial system is only based on the Supreme Court. If the cases is under the Supreme, is under the authority of Supreme Court, as well as like in the, it is the same like in the Constitutional Court and the Judicial Commission. Even though in Indonesia itself, judicial commissionary is exists as independent institution, but its existence doesn't also interfere the Supreme Court, like what actually president cannot also interfere. So in this context, if you ask me about does the president can do an appointment or such things like that in regard to the cases, to influence the cases or anything in regard to the judicial commissionary or all aspects of that, actually those authorities are different. Their power each other is only to control each other. Even they have an appointment, there must be not talking, there must not be anything in regard to how the cases should be broke. It's more like how the techniques no, it is in regard only, it is almost like a technical things, so they can be different each other. So I think that's answer a very first our main idea how the judicial power is implemented actually in Indonesia. Supreme Court is not highest court. It is highest court for each body under that, like a district court, religious court, and so on. But other than that, remember we also have a constitutional court, and we also have a, which those three judicial powers are at the same level. So we cannot assume that a president is highest or Supreme Court is highest than judicial commissionary. No. For the example, in conducting or in establishing the conduct or ethical code for the judges, the judicial commissionary doesn't need to ask the proof. No, not even doesn't need. They need to ask the proof, but the level to ask the proof is not how actually they should. I mean, they should together approve the establishment of it. They should together agree on that establishment. They should maintain it together. So those institutions are the same. They collaborate, not the Supreme Court as the highest, I think. Yeah, hopefully it answers and it answers your questions.
Yes, sir. Thank you, sir.
Thank you.
Sorry, sir.
Okay. again, there is,
Sorry, the time is up at
okay.
40, but maybe you want to continue or close the class?
Continue. But they slightly asked me to give an like a quiz or something. Is it needed or not?
Sorry,
But
sir.
yeah. But they slightly several days ago asked me to give a quiz or something to the audience, to the students. Is it still
Oh, yeah.
needed or not?
It's okay if sir want to give the quiz, I think, but we can ask for the participant first if they can okay, if we give the additional time maybe.
Oh, no, no, no.
So,
I think to make it simple, I think just for the audience, resume all the materials we discussed today. That's, I think, submit all the I mean, that's what we need actually. Submit all the review and overview, and also resume the materials we have today. What is your critics to Indonesia, your command, and how you understand this judicial system power? So that is the job for you guys, perhaps. Resume it, and then I'll see the results. I don't know, perhaps the committee will give it me, and I'll see that. Thank you so much. If there is no time more, hopefully this will be so much benefit. Even this is so little, so much little, I think. So you can, if you want to know more, explore it more. It is just a short course. Short is short, isn't it? So it cannot be more than that. Thank you so much for your attention. It's really nice to meet you guys. Assalamualaikum warahmatullahi wabarakatuh. Okay. I leave, yeah. Thank you.
thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you,
Thank you,
sir.
sir.
Thank you,
Guys,
sir.
Thank you, sir.
Sir.
I would like to remind you all, don't forget to fill in the present because I will close at 12. Thank you for your attention. See you later.